Well, just a few weeks ago, or a couple of weeks ago, Dr. Federico Lenzerini, a professor of international law from Italy, came to Hawaii at my invitation, and he's actually on my legal team. So both he and I represent the Hawaiian Kingdom government in fact-finding proceedings at the Permanent Court of Arbitration. These proceedings stem from the Lance Larsen versus Hawaiian Kingdom arbitration that occurred from 1999 to 2001. The arbitral tribunal actually recommended that the parties should consider going to fact-finding. These proceedings were initiated back in August. Dr. Lenzerini and I, we were part of programs that were based on education. The commitment schools provided a platform, a space to present also these proceedings. And this was done on January 30th. And it was focused strictly on the proceedings, not necessarily the educational aspect, which was an earlier presentation. And these proceedings were very much to the point, just providing an opportunity for people to understand what's going on at the international level. And Dr. Lenzerini brings in an additional sense of credibility. At this presentation, at the auditorium at the Kamehameha Schools, Ruth Ke'eliko Lani Auditorium, over 700 people were in attendance. The response was amazing. It's like they were hungry for information. And I have to say, this is as a result of my work and other people at the university who are teaching this. There are more PhDs that focus on these particular areas of Hawaii as a country. I sit on doctoral committees. That was my intent when I returned from the Hague back in 2000 to begin to address education. And the education that we have today and the awareness is night and day compared to when the Permanent Court of Arbitration proceedings took place between 1999 and 2001. It's an exciting time for me. It's like the fruit of our labor, the fruits of our labor. And for Dr. Lenzerini to be there to witness that, it was strong, and people were embracing it. So in this case regarding the Larsen case, Larsen versus the Hawaiian Kingdom, what many people don't realize, or they didn't realize at that time, was that before the Permanent Court of Arbitration can create a tribunal to address a particular dispute, one of the parties has to be a bona fide country, a state. That's the term that is used in international law. So the Permanent Court of Arbitration in 1999 had to verify whether or not the Hawaiian Kingdom exists, because this dispute that arose out of Hawaii's prolonged occupation and the illegality of the state of Hawaii centered on the alleged violation of Lance Larsen's rights, because he was alleging that the Hawaiian government, which I represented, neglected to protect him when he was put on trial, an unfair trial, and subsequently incarcerated for following Hawaiian law. Yeah. So that dispute of negligence, we were denying, but before we could address that particular dispute, the Permanent Court of Arbitration had to verify if in fact the Hawaiian Kingdom still exists as a country, and that the Hawaiian government is in fact the representation of that country under international law. And they verified it. They verified it. And by March, they had concluded that the Hawaiian Kingdom exists. And that's what prompted the creation of the tribunal. And that tribunal was created in April of 2000.
Please be seated.
Okay, so Lance Larsen went to trial at KL District Court. Judge Sandra Shuri was the judge. And Lance was represented by Ninia Parks, an attorney. And Lance was claiming that he didn't need to have a driver's license because there was no driver's license requirement under Hawaiian Kingdom law. And he took that position. And until the state of Hawaii could show that there's a treaty where Hawaii legally is a part of the United States, then American laws, which includes the state of Hawaii revised statutes, would apply to him if Hawaii was a part of the United States. That was his argument, and he was represented by an attorney. Sandra Shuri, the judge, could not answer that question. Instead, what she did was she fined him, I think it was about $900, that's what I got from the pleadings, and put him in jail for 30 days 7-day solitary confinement. Now that's pretty outrageous, okay? So he was detained by the sheriffs in the court, taken to the jail, and his attorney quickly turned to the Hawaiian government, the acting government who I represent, yeah, and says, you're responsible for the protection of my client. I said, no, you're right. We do carry that vicarious responsibility, and we are the acting government, like a government in exile established during occupation. But we've done everything that we could to protect your client. She says, that's not good enough. And she was honestly afraid for him getting beaten up in prison. So she was panicking, right? Well, that eventually led to an agreement to arbitrate, okay? And in this agreement to arbitrate, we agreed that your allegation of the Hawaiian government being negligent for allowing American laws to be imposed in Hawaii, which led to your client's incarceration and unfair trial, should be taken up before the Permanent Court of Arbitration. So that was the basis of our agreement, okay? Now, we're the defendants in this case. We're not the moving party. She's the moving party. She's the plaintiff, per se, called a claimant. We're the respondent. When she submitted the notice to arbitrate to the Permanent Court of Arbitration in November of 1999, the Permanent Court of Arbitration is an intergovernmental institution. It is not a court, okay? So the Permanent Court of Arbitration is kind of a misnomer. It's actually an institution that creates ad hoc tribunals to address particular disputes. That's their job. Now, what the Permanent Court of Arbitration has is what is called institutional jurisdiction. Institutional jurisdiction means that before they can create an ad hoc tribunal, they have to ensure that the parties have an international dispute. And to have an international dispute, in this case, one of the parties has to be a bona fide country called a state. That's the first step. What ended up happening was from November 1999 until February of 2000, the Permanent Court of Arbitration, the International Bureau, headed by the Secretary General, in this case, Van den Hout, he's a Dutch national, they were vetting this question, or this issue, trying to determine whether or not the Hawaiian Kingdom exists as a country. In mid-February 2000, I was on the phone with the International Bureau asking a question on a procedural matter, because I was representing the Hawaiian Kingdom government, who's the defendant in this case. After I received the answer from the person at the Bureau, she tells me, Mr. Sai, please hold on. The Secretary General would like to speak to you. I said, sure, no problem. He comes on the line and he tells me that they cannot find any evidence that the Hawaiian Kingdom does not exist. He even acknowledged that the treaty between the Hawaiian Kingdom and the Netherlands has not been canceled. So that's what he's sharing with me. And then he followed up and he said, in order to maintain the integrity of this case, he recommended to me that the Hawaiian Kingdom government provide a formal invitation for the United States to join in the arbitration. Now, to give you an idea here, we are not addressing the dispute with Lance Larsen because the tribunal has not even been created yet. This is an administrative process. So for him to ask the Hawaiian government to provide an invitation to the United States to join in the arbitration, because they were the ones, according to the dispute, arrested Lance Larsen and the subject of the problem here, it is very important to know that they're asking us to do it and not Lance Larsen's attorney to do that. Now, I can understand why he wanted that. I can understand why he wanted us to do that. Me in particular, representing the Hawaiian government. Because if anybody can refute the existence of the Hawaiian Kingdom, its existence as a government, as well as a state, would be the United States of America. Because if they can refute the Hawaiian Kingdom and show the Permanent Court of Arbitration that Hawaii is the 50th state, then there is no case. They don't have to move forward to create a tribunal because it would immediately fall apart. Okay. So that prompted myself and Inia Parks, the attorney for Lance Larsen, to travel to Washington, D.C., and we delivered the paperwork of the case to the State Department, and we're told that it was going to be given to this person named John Crook, and he's their legal advisor, one of the legal advisors, and that we could either call him later on that afternoon or the next day, the next morning. So when we had our meeting our conference call meeting with John Crook, I explained to him that I represent the Hawaiian Kingdom government and that we're in arbitration proceedings at the Permanent Court of Arbitration with Lance Larsen, who's in this conference call represented by his counsel, Miss Ninia Parks. I remember John Crook asking the question. He said, the Permanent Court of Arbitration accepted this case? I said, yes. In fact, the Secretary General recommended that the Hawaiian Kingdom provide a formal invitation to the United States to join in the arbitration, which is the purpose of our meeting. And that's when he started to watch his P's and Q's. Because I did share with him that our meeting will be reduced to writing and submitted to the registry of the court to show that we follow through with their recommendation to provide an invitation. When the meeting came to an end, I put it together in an email of what took place, well, actually a letter, sorry, sent that letter to John Crook on what was covered, and I carbon copied the Secretary General. 1 week later, I get a call from the Deputy Secretary General, Phyllis Hamilton, and she explains to me that the American Embassy in The Hague has notified the court that they do not accept the invitation, but that they ask permission from the Hawaiian government and from Lance Larsen, permission to access all records and pleadings and transcripts. And I responded to this Deputy Secretary General, absolutely. Now, that right there is important. Number one, the United States did not dispute the existence of the Hawaiian Kingdom as an independent state. Second, they directly recognized the Hawaiian Kingdom government to seek permission to have access to the records. Only governments of states can be brought into the Permanent Court of Arbitration. Private people do not represent countries, only governments. It was after that that the Permanent Court of Arbitration could now definitively say, without a doubt, that the Hawaiian Kingdom still exists as a state. And that's what prompted the Permanent Court of Arbitration to begin that process of establishing the tribunal, which took place within the month of April 2000. Now, once the tribunal was established, pleadings were submitted. Then a procedural order came out in July, procedure order number 3 from the tribunal. And the procedural order stated that the plaintiff is asking the tribunal to determine and adjudge that the United States violated his rights when he was put on trial and incarcerated. Then it says in the procedural order, after they determine that, then the plaintiff is asking the tribunal to adjudge and declare that the Hawaiian government is liable for the violation of those particular rights. So we're a second tier on this procedural order. The first tier is whether or not the United States violated Lance Larsen's rights. This is what brings out a particular rule in international proceedings, whether arbitration or litigation, indispensable third party. The rule is this: before an international tribunal or court can review the conduct of a state, whether lawful or unlawful, who is not a party to the case, they can't proceed. They have to be a party to the case. And that is called the indispensable third party rule. So Lance Larsen, before he could come after the acting government for negligence, he needed the United States as an indispensable third party. Without the United States, he didn't have a case.
The UNCTAD rules on the face of them require that the dispute be characterized as commercial. That's a matter between the parties, and the basic principle of the UNCTAD rules is party autonomy. So as between yourselves, you can waive that requirement without any difficulty. The problem, it's more difficult to waive a requirement of the consent of a third state if there is such a requirement.
Can we proceed in the absence of the United States?
And Mr. Dubin, that's the issue, whether you go under one set of rules or the other.
Exactly.
Yeah.
Throughout the proceedings, though, the issue centered on the indispensable third party. And that was the basis of the oral hearings in The Hague in December of 2000. The burden was not on the Hawaiian Kingdom government to address the indispensable third party. It was Lance Larsen. Now, the Hawaiian government, we utilize these proceedings to our advantage to get more clarity on what is the relationship between a government and a national during occupation. It's a very extraordinary situation.
Rather, what we find is that the United States has never expressed itself as an occupier. Who would? They will never admit to occupation. But yet, to admit to occupation is, in a sense, to admit to the continued existence of the Hawaiian Kingdom as an independent state, which is really the crux of the matter, which is actually what is holding up, you might say, this issue to be resolved. Thus, the legal order, thus, the reestablishment of the government, thus, the relationship between its nationals.
And through the proceedings, at one point, the tribunal recommended that the parties, in order to address other issues that would not apply to the indispensable third party, like a relationship between an acting government and a national, the law of occupation, the role and responsibility of the Hawaiian government, we could possibly go to fact-finding. And fact-finding is another process or a part of this, a part of a resolution that the Permanent Court of Arbitration also administers, in addition to arbitration and mediation. Okay, so that's what the whole case centered on. Ultimately, Lance Larsen could not proceed against the acting government without the United States involvement. Okay, so the defendant, as a defendant, we won the case, right? But that didn't correct the problem of Lance Larsen's rights being violated. Lance Larsen is still a victim, and he still deserves redress. It's just that he couldn't hold the Hawaiian government accountable as a result of the United States not being a party. But it did not take away or mitigate or lessen any of the pains that he has endured as a victim. So we did initially enter into an agreement based upon the recommendation of the tribunal in its arbitration award to go to fact-finding. But I eventually knew that we needed to address other matters first, and that was education. So we entered into a mutual agreement where we're going to withdraw from fact-finding, and we will take up the issue of Lance Larsen's rights. But in the meantime, education. And in the after returning from The Hague, January of 2001, I entered the University of Hawaii Political Science Department to get my master's degree, specializing in international relations and public law, and ultimately get my PhD, which I did. Everything that took place in The Hague verified perfect title was correct. Everything in my doctoral dissertation verified perfect title was correct. And that my trial on this trumped up charge of attempted theft of land by doing a title report, it was manufactured. It was completely manufactured. That's a war crime. That's an unfair trial. It's not malicious prosecution. No, this is an unfair trial. Under Article 147 of the Geneva Convention, that's a war crime. There's no statute of limitation on that. Yeah? That's what I understood. So I could fully understand and empathize with what Lance Larsen was going through, because I went through it. But I'm part of a Hawaiian government, whether people believe it or not. We represent the Hawaiian state. We don't represent the Hawaiian people. And that is what is called like a government in exile. You don't have the normal capacity as a government as you would during peacetime. When you're occupied, the government of an occupied state has no effectiveness. That's the rule. It doesn't, because if it did have effectiveness, we wouldn't be occupied. But there is a responsibility on the occupier to administer the laws of the occupied state. The purpose of the acting government is not to get people to follow what they say. The purpose of the Hawaiian government is to expose the occupation, and that the United States has not complied with the law of occupation, which has led to our present predicament today, where everyone is holding the bag that insurgents once held. And we all have been living a lie that Hawaii is a part of the United States. So I had to take the time to go and get a PhD on this topic. But I took the time to actually purposely select professors, experts in certain areas to be on my doctoral committee to address these very complex and hard issues. And I could not have gotten that PhD without them signing off on it. And the last person of my committee to sign off, the very last person, where I had to meet with him in his office at the law school, was Avi Soifer. And he was going over this like with a fine-tooth comb. And every comment he had, I had a response because I have to defend it. And then at the end, I said, Avi, you got any more questions? He says, no. So you're going to sign off on my dissertation? Yeah, signed off. From there, it went straight to grad division, and I graduated. It's not that I need to argue the kingdom exists. You have to show me it doesn't exist, because I'm operating on the premise that it does exist because I have proof that Hawaii had treaties, one in particular with the Dutch, the Netherlands. I know that Hawaii had an embassy in Washington, D.C. I know Hawaii had an embassy in London, Paris, Amsterdam. I know that. So I know it did exist. Therefore, it still exists until you show me it doesn't. So it's really, can you falsify this fact? Not, are you going to agree with me that this is the fact? In a dissertation, when you do your doctoral research, and all research is done, whether master's or PhD, you do not argue the facts. You basically provide the facts, and these facts are either falsifiable or not. The job of a committee is to falsify. That's it. So what was presented to the Permanent Court of Arbitration was merely, can you falsify it? There's no argument here. And they couldn't falsify it because the only way that you can show that the Hawaiian Kingdom does not exist is international law. Where's the treaty? Instead, all you have is American laws passed by Congress being imposed in Hawaii, which is the subject of the dispute, right? So that administrative stage was so important. And if anything, that is where the Hawaiian Kingdom government was involved. As far as the proceedings before the tribunal, well, that's when the Hawaiian government was a defendant. We were not a defendant in this administrative process. We were a player. And we were in communication with the court. And that's what stumped everyone. You know, they just couldn't believe it. People like Dr. Federico Lenzarini, who's on my legal team, oh, he fully understands that. You don't have to explain to him about the presumption of continuity of an independent state, despite its government being overthrown, because you can continue to exist as a country without a government. You know, Italy is a prime example. When Mussolini was captured, the Nazis occupied Italy. That was not an Italian government, but that didn't mean Italy ceased to exist. You know, so we have examples out there.
Iraq, like you said.
And Iraq. Yeah. In 2003, the United States military overthrew Iraqi's government, Saddam Hussein, but that didn't mean Iraq ceased to exist. Period. You need a treaty. You need to show that Iraq joined the United States, or in this case, Hawaii joined the United States. It didn't. It was occupied during the Spanish-American War. So this history these are hard facts, and I get it. It's not a problem, but don't attack the mailman for delivering the mail, right? But I took those extra steps within this society to utilize the academic world to address this, not the political world.